There's night glow, go shining bright, colors dance in the night. You don't owe them a thing, it's not up for debate.
Is that right? And welcome. I wanted to do an open panel because things are just so explosive right now, especially with all of the allegations and what Cyree has said. And I wanted to start off by saying, I think we all knew that something was wrong with this case. We just weren't sure what. I want to remind everybody about, hello, Eddie. Oh my gosh, I would love if you would come up, if you'd like. I wanted to remind everyone about this. I'm going to put the link in the chat about the response to the state's motion for protective order. How do I hear that invite? Good to see you. So even though in here it says, Jay Locks wrote this, right? Yeah. The state appears to be trying to hide its original domino. What if he was talking about something else, which would be the timing advance reports? Or it could have been the original domino, because there might not be any real IGG. Because in the beginning, we all knew something was wrong with this case. And now we're finding out Prosecutor Ashley Jennings, I guess she hid the timing advance reports. And there's only one reason why she would hide those. Because they don't place Brian at the scene. So she can't have anybody see those. Otherwise, why wouldn't she use them? That's the only option, I think. But the domino is the timing advance. Can you guys believe it that we all knew something was wrong and something is wrong? Really, really wrong. So I'm still curious to see what everybody's first reaction was, where you're like, something's not right about this case. Let me ask a few more questions. For me, it was reading the PCA and reading the words, oh, Eddie, frozen shock face. Oh, hi, Eddie, welcome. So good to see you.
Good to see you. How are you?
I'm doing great. I'm doing great on this lovely Saturday. How about you?
Not too bad. Thank you for asking. Yeah, I agree with what you just said.
Yeah.
So they would definitely know that Brian Kohlberger was not at that crime scene, not anywhere near it. That is the only explanation of this. And you're right. We've been all along suspicious of this. We tried taking the PCA as a fact in this case from the beginning, and we went as far as we could with that, but now we know that it is only lies, and it is no longer something that we depend on as far as what we use to have an understanding of what happened that evening in that house with this crime. And because we can no longer use the PCA because the state has proven themselves liars, that would mean that Everything else the state is going to be trying to tell us and have us to try to use as a fact in the case. We know that that is no longer dependable. It is the same state that has been lying to us this entire time, and it is slowly coming out through all these documents that we're learning. So liars, Jeff.
Yeah.
Yes.
It's so incredible. Do you have any insight on that these decisions that apparently Ashley was taking?
Well, because she's been part of this investigation from day one. She's aware that there was no, just like Ann Taylor said, there was no real investigation done. This document by Ray, it is showing that the defense knows, they probably know who is really involved with this quadruple homicide. And they are prepared to blast that out. You can tell the strong language that Ray is using in this towards the court. It is kind of like a warning shot being fired to Judge Hippler, because the defense knows that Judge Hippler is being manipulated and directed, and he has thus far been corrupt.
Do you think that is Hitler's doing, or is he just following along with Ashley in the state? Or both, I guess.
They are all involved. They are all on board with this. And they're all being directed to do their part, so to speak. I don't think Judge Hippler is doing this of his own volition. It is more like he is compelled to do it. He's got no choice. That is the feeling that I'm getting. And the same with Judge, too. The same with all the people who are actors in this. Something is so corrupt that it has to be buried and never see the light of day. And they are willing to go through and take whatever action is necessary. They don't begin such a corrupt scheme as what they have undertaken here without being prepared to see it through to the end. And I fear that they will somehow or another see it through to the end.
Okay, another question for you. What do you think? You mentioned something about there's something that they are willing to ride out to the end with. Do you think that has anything to do with whoever is really responsible, or the reason behind it, or something else?
Well, there's people in such high places, in high positions in the community that are possibly involved with this. The actual perpetrators of the crime are not the only guilty ones, I don't think. But identifying the ones that carried out the quadruple homicide, identifying those persons will reveal what is ultimately behind this entire the entire reason why it happened. And that is what they absolutely will go to any length to prevent from being exposed.
Wow.
Is that Jeff H's second alias? Is that you,
Yeah.
Jeff?
Yeah, that's him.
You know what I've
I don't
noticed
know
though
why
is
he. Go ahead.
what I've been noticing is the more the truth is slowly coming out, the more that the guilters resort to underhanded tactics in order to like squelch or silence the ones that are trying to speak the truth. I've seen some podcasts where they show pictures of like some of the defense team. Like, everyone takes a good picture and a bad picture, and we see this, of course, a lot in politics. The red team and the blue team, the news channels during like election time, they will show the worst picture of the opposing candidate to try to display them in the most negative light. And we're seeing that some of these podcasts take like the worst photograph of some of the defense attorneys and then gaslight with like, look at this crazy lady, and now she's coming on their team and gonna try to you see what I'm saying. They're resorting
Yeah.
to, and then now with the release of Brian Koberger's recent selfie, instead of focusing on the facts of the case and looking at these documents and asking the real questions, like what is behind all of this? Why in these text messages, these girls were obviously aware of what happened that night. They're not asking questions like that. They're just resorting to superficial discussion points to try to misdirect everyone.
Definitely have noticed that. I
And
had
take the
just
attention
posted something
away.
on Twitter about that. I'm sorry, go ahead.
I'm sorry. They're just trying to continue the gaslighting that they've really, for 2 years or more, have been enjoying in this case. That was my point.
Yeah, it was August of 23. I had posted on Twitter that I think it was like right after we found out that there were 3 unknown male DNAs, and 2 of them were found in the house where the deceased were located. And I had made a comment, well, whose DNA is under the fingernails? I would like to know that information. I would like to know the identities of these 3 blood DNA samples. And I was like, these are really important questions to ask. And somebody had like shamed me into saying that I was providing misinformation. And so I retweeted it, like I think it was either today or yesterday, and I was saying, look, this is one of those things. I was, shamed for asking a question, and this shaming campaign is just out of control because these were genuine questions that are based in science, and so there was no disinformation here.
Yes,
So
very good point.
I also think that'll start changing too. Now, well, like you said, maybe they'll double down, but I turned the tide with that one. What were you going to say?
And you bring up a good point, is with those unknown male DNAs, the only way that if this was a true investigation, they would have been looked into. But the fact that they were never even run through CODIS or tested, and they don't even exist anymore. The defense does not have those blood DNAs, turned over from the discovery to them. The only thing that could explain that is if it would be that the crime was already solved by the prosecutors. That could be the only explanation to not looking into those unknown DNAs. In other words, they already knew who they were and knew who committed the crime and knew that they could not be identified or revealed. They had to be buried and thrown away into the deepest, darkest hole so that they could never be discovered.
Well, it appears from one of Cyray's documents that whoever it is had AT&T during the time frame of the crime. What do you think?
Yeah, let's look at those documents. Which one do you want to start with? So. We got the vague and undisclosed expert testimony, or we can do the AT&T timing advance records.
Yeah, let's do the what do you think about the timing advance record?
Okay, let's pull that up.
Do you see it?
Yes. Right. We'll skip through the normal introductions. That's redundant. Mm-hmm. This is the lengthy one. Yeah. Okay. Okay, what's a good place to start? Maybe on top of page 3. Kind of like AT&T timing advance. In August 2021, I was approached by an FBI special agent. Okay.
All right, got it. Can you see it? Let's see. I can make it bigger.
Yeah, and I'm on my own screen, but yeah, I can. Okay, I can see you. Yeah.
Okay. Right. Mm-hmm.
Okay, so the defense, as we know, the defense has been trying to fabricate the tale that that did not even exist in the year 2022, right? The ability for timing advance records. So here we're learning that is not the case. That software did exist. So point number 4, he's saying, I have firsthand knowledge that AT&T was providing the FBI with timing advance reports prior to August of 2021.
That's incredible. Wow. What does that do to Ashley when it's so clear that she really misrepresented to the court? Even more so.
Yeah, and I'm trying to scroll down, but eventually what we're going to see is that the prosecution did have timing advance in this case. 3,800? I'm still scrolling here.
Here we go. It says missing AT&T timing advance. And I think number 2 is the first time, or is that the second time we see 38? I thought that was the second time. Okay, either way, I see it down here under missing AT&T timing advance. Number 2 says the FBI demonstrated their ability to obtain AT&T timing advance in November of 2022 by obtaining AT&T timing advance records on over 3,800 mobile devices, none of them being the defendants.
There you go. So they had records for like everybody in the community except the alleged perpetrator of this crime. How convenient. Could it be that having the timing advance records for that alleged perpetrator would actually show that he was nowhere near the crime scene, since timing advance technology is the most accurate way to pinpoint one's location?
Right. And that could be the only reason. Like, I don't even know if I'm comfortable saying, oh, well, maybe there was something ambiguous in it. Because they've been trying to move those ambiguous facts, so-called facts that they say, and trying to paint a picture with each one, especially which I don't think they have proof that a K-bar, a sharpener, or a sheath was purchased. I think they have these two experts where they're going to try to paint the picture. So even if there was some ambiguous data in there that they could use through their benefit, I believe they might have. But so I think you're right. In there, it must show the defendant was nowhere near the crime scene. I just want to say hello to Kathy. She's here. Good to see you. Oh gosh. All right.
So on the top of the last page, which is page 7, yeah, it
so
says
sorry
it there.
about that, Kathy. She's gone. Oh, Kathy, you're so good to me. Thank you. So we're going. Oh, Kathy, you can come up too. All right, so we're on the last page. Is it the number 3?
Let's see.
That number 3 is powerful.
Yeah, it says on the top of the last page, letter B, lowercase, there is overwhelming evidence showing the state obtaining and using AT&T timing advance data in the course of this investigation in 2022 on over 3,800 AT&T mobile devices, other than the defendants. C, there is no doubt the author of this current motion, Prosecutor Ashley Jennings, knew or should have known AT&T timing advance data did exist in 2022. She was directly involved in the legal process obtaining it and was aware of work product created from it to further the investigation. The current motion is a deliberate misrepresentation to the court to further conceal false statements used to obtain probable cause against the defendant and conceal exculpatory evidence from discovery. That is significant. That proves that he wasn't there, and he's prepared to testify as such. Which brings us to, make a note of your earlier live stream today. We were discussing the fact that he's not going to be allowed to testify on the April 9th hearing. That is very interesting.
How do you think Judge Hippler is going to react? Do you think he would be forced to take a look at this? Oh, whoops. Or
well, I think
would he?
You know how people are. They hear what they want to hear and then disregard anything that contradicts their belief. So it is like a protective mechanism. If he's afraid that Cyree is going to demolish the state's argument, then the best way to guard against that would be to limit his ability to testify during the hearing, which is what he's done. It's an underhanded move. It's a deliberate move.
Yeah. I'm worried about it.
And we should be, because we've already seen the way he has a tendency to rule, and it's a one-sided biased way of rule.
A tendency to rule, and it's a one-sided biased way of
I'm hearing an echo.
We got some feedback.
One-sided biased
way of hearing an echo.
Can you have the YouTube one twice? What? Okay. No, I guess she'll come back.
Yeah, there was a
So
echo when she was up.
Oh, where was I? I hope that this forces Zippler to take a look at it. I mean, I think you were right when you were saying that they kind of had to, back the judge in the corner as well, or they wouldn't be able to move forward.
Yeah, it certainly seems like the judge is in their corner.
Yeah, because down here it says, I think I was saying before that I think this is a direct dig. Anyone making such a claim would have to believe the court is incapable of reviewing physical evidence in the possession of the state and the defense. Like, is he directly talking to Hitler in that sentence?
Yeah, he's directly talking to Hitler. He knows.
I keep trying to hit add. Sorry, Kathy. So he knows.
Yeah, Audrey, I agree with you. He is certainly talking directly to Hitler, and he's using strong language because the defense by this time knows that the time for politeness and keeping the conversation like proper and cordial is about over, because things are getting critical and they're kind of like firing a shot across the bow, so to speak.
Mm-hmm.
It's a way of announcing that because you guys are playing underhanded, we're ready to get serious ourselves.
Right, they kind of have to at this point, and it's totally amazing how Anne did put together this team of people who are top in their field, and both of them. I mean, even Eliza, and one of those where she says the state chose to focus on the defendant at their own peril, and then we have Bicka Barlow outright basically impeaching their DNA witness. And now we have Cy Ray calling out the actual prosecutor, and the judge a little bit as well. So, this is full force. You're right. They're coming at all angles here.
Did your mic get muted?
Uh-oh, I bet you it did.
Okay, I caught what you said, though, and I agree. Yeah, all of what we're seeing, it can only mean one thing. And some have known about it for a long time, but Bryan Kohberger has no involvement in this crime whatsoever. He is truly innocent. And even the state knows that. Part of this whole disinformation campaign is a trial by media because he is innocent, and they're going to have a difficult time proving a case, and it's just going to be a case made by innuendo and lies, loose connections, such as what we've seen already. You know, here's a knife sheath, and here's a grainy image of a white car similar to his appearance, and a bushy eyebrow. There, you know, it's going to be a case that's dependent on the media to try him, and it's a concerted effort, and that is an effort that is purposeful and performed by the state. In other words, they're financing this disinformation campaign, and they're having the media push their lies. They're financing the media through your tax dollars. It is your money. When I say you, I always mean you, plural, everyone who's listening. You have paid for them to do this to Brian Kohlberger. How does that make you feel? You should feel angered and violated by that. A government has no ability to manufacture their own money. They don't build anything. They don't do anything. They don't perform any tasks, but they absorb your dollars, and your money funnels into their coffers. They don't produce money. So if they're financing this, which they are, it is through your hard-earned money. And that is a psyop that is going on against Brian Kohlberger for whatever reason.
Oh, do you ever speculate about a reason why they would target him? I always thought it was just 'cause he was convenient in some way. Do you have any thoughts about that?
Yeah, that is a fascinating question. And of course, we won't have an answer for it. We'd all love to know why. Well, I guess it had to be to somebody. So in the end, I guess it really doesn't matter. Because no matter who it would have been to, it same question would have been asked of that person. I think it's more than just random. I think there is an explanation rather than randomness to it. There is a method, in other words, why it was him. It seems like it's been going on even prior to the crime, just in my opinion.
Oh, do you think there's a possibility they targeted him before the crime?
Yeah, it could be. There's things kind of suggesting that.
That to me says, did Ashley or law enforcement know this was going to happen before it happened? Possibly.
Isn't that a fascinating thought?
Chills.
Yeah, I just don't know. I mean, he did buy a K-bar. I guess there's no getting around that. It doesn't mean anything suspicious on his part. There's a lot of static. Is that on my end? Or is
Hello,
that...
Kathy. Welcome.
Hey,
I'm
how
sorry,
you
go
doing,
ahead.
Audrey?
Hi.
Hi, Kathy.
Hi. I don't think we've met before, have we?
Not on panel, no. So hello.
Hi, it's great to chat with you today. Yes, Audrey, we are now, what are we? 11 days to the in limine briefings, and my goodness, with these recent filings, there's no doubt. I think this case is going to be won or lost depending on Judge Hippler's pen after oral argument on the 9th and 10th. What do you guys think?
I think you're right. I don't have high hopes for the way he rules.
Mm.
As far as, you know, if one is siding for justice, for true justice, if you follow my meaning there.
I don't know. I've not really been impressed by the defense's track record so far. They've lost. I mean, the last major battle they won, and it was a long one, was a change of venue. But they lost every single motion to strike the DP. They filed their Frank's hearing materials late and in disarray, which got them a slap on the wrist from Hitler. And he allowed them to file their filings late. They lost every single suppression motion, didn't argue standing. I think those suppression motions could have possibly, maybe could have been won if, for example, there was some sort of a creative argument that, yes, he did have standing relative to these tests that people took to find out about their DNA. Could have said maybe something to the effect of, that's my DNA as well, and I didn't sign off on anything. But she was gung-ho on policies and procedures, and that got the memorable and ruling and statement from Judge Stephen J. Hippler of, well, isn't probable cause on a piece of DNA found on a sheath at the crime scene probable cause every day of the week and twice on Sunday? That was devastating to have him say those words. But she did not argue standing. And now, now we've got a very critical, important defense witness, and she's filing a statement from him, an affidavit from him 1 month and 2 days after filing the motion in limine to suppress the jury from hearing some of this evidence. Hippler told her 10 days ago, file an affidavit with respect to the alibi defense. They've pretty much abandoned that. I don't see one alibi defense declaration or affidavit from Mr. Ray. And now there's this declaration or this affidavit that really requires a response from the state. And that may require the hearings and the in limine schedule to have to be moved a second time right now. So I don't know. I don't know how effective they've been. I think Alyssa Massoth, she's appeared before Hippler before. And in my opinion, I wish that she would have more of an opportunity to argue a lot more in front of Hippler. But Taylor wants to, continue to be lead. They've got Becca Barlow, who I think is, a dynamite addition to the team because of her background in DNA. But if they lose these hearings, I think that, Mr. Koberger has, some thinking to do regarding what he wants to do about his defense counsel going forward. That's just my opinion that I offer.
Yeah, those are some good points.
His life's on the
Um,
line here. This is a capital case. This is not about anybody winning, making a name for themselves. This is a capital case. And there's some evidence on the record that's circumstantial that is very damning against him right now. Juries have convicted on a lot less circumstantial evidence. I think that you had made the point that, there's a trail that a Amazon sheath knife, I don't want to say that word, unaliving blade and sharpener was delivered to his home in Pennsylvania. And guess what? During the raid in Pennsylvania, none of those things were recovered. So all of this could be completely innocent, explainable, but people need to put their egos in the back seat right now, because this trial is coming very, very quickly. And in my opinion, it's not looking good for him right now.
I don't remember seeing where it says that anything was delivered. I mean, I could have missed it, but I didn't see where anything was delivered.
They have not disputed that point, and the state says that they have witnesses, not expert witnesses, but fact witnesses, Audrey, in that footnote who will be able to testify that that was his. Now, if that turns out to be some sort of expert witness, that will be a big letdown and, you know, a slap in the face to the state. But if those are fact witnesses who are able to say that, that's going to be a problem for him.
Kathy, what do you
I'd
think about
like to
these
see this.
lies that have been coming out about what the state has done throughout this investigation?
Eddie, yeah, I know. I saw that this morning. I was looking at that, the affidavit of Cyrus. And again, that extends the motion in limine a month and 2 days. Hitler extended the deadlines because the parties went to him back in January from the dates that the in limine filings and hearings were supposed to be held. So he extended that, and he told them 10 days ago, Cyrus cannot appear at hearing. He cannot appear. You don't usually have live witnesses at in limine hearings file his affidavit or declaration. And I don't know why they waited 10 days to do it, but it's filed a little bit late, I think. And these are some explosive allegations against Miss Jennings here. And I think that the state should have an opportunity to respond. So I don't know if Hitler is going to allow them to respond, maybe change the in limine hearing date on this particular motion, because this is the defense motion. The other two motions were the states, the motion to strike the alibi defense and the motion regarding AT&T. That was them responding to the state's motion. This is their motion filed on February 24th. I wish that what she would have done, I wish she would have called Thompson like she did in January and said, we're going to go ahead and I'm going to file this. Can we put a stipulation that you have how many days to respond? They didn't do that. So we're going to wait to see what happened. This next week is going to be crucial. We have to see how Hitler's going to respond to this. Because I think that it can't be ignored. I mean, this is beyond misconduct. This is, deliberate, intentional, what he's arguing here. And I think that the defense should have, or the state should have an opportunity to respond to it, not at hearing, but in the form of a response. So we'll see what the state does, what the defense does. This may get those hearings kicked, or maybe not all of them, but at least to this one, because of the explosive nature of some of these allegations.
Yeah, there's strong language for sure in Cyrus' filing there.
Yeah, Audrey, one thing that we talked about the other day is, what about where's the affidavit in support of the alibi? I mean, that was the whole reason for bringing Cyrus in. If we go back to Latah County days, I think it was April when the state served a demand for discovery, and hey, Mr. Koberger, if you're going to raise an alibi defense, this is what we need. And the statute says names of witnesses, what your location was, and so forth. And the defense asked for an extension to respond. They did. They agreed to that. And when the defense responded in July, that's where it said Cyrus will be able to provide corroborative information that Mr. Koberger likes to go out driving, at nighttime. And I can tell you, I've got people that follow me that live in the Poconos area or work in that area, and they say, Kathy, that is true. They go out all hours of the night and they go up hiking in those mountains. It's a place where you think about Pennsylvania, New York, that's a very, very, industrial area or cosmopolitan area. And then you have the Pocono Mountains in between. So people that live in the Poconos will go out all hours of the day and night, is what my followers who live there tell me, or have, are familiar with the area tell me. Okay, so it seems like it's not a big deal that he would be out driving at night, but Cyrus was supposed to be able to substantiate that partial alibi defense. We haven't seen any declarations or affidavits from Cyrus. Audrey, did I miss it? Did you guys see any?
I'm hoping that this document right here, these new affidavits from Cyrus, supersede the alibi defense. And I hope that this is a disruptor to how court normally goes, that yes, technically there are things that probably should have been done, and how it normally flows with the next couple of things that are coming up. But I hope this disrupts all of that, because I
Well,
think this is pretty spectacular.
They've
Go ahead.
already been admonished twice by Hitler. Hitler likes his deadlines. You know, he is the administrative judge. Orders are put in place in order to, to one thing relates to the next. Everything is leading towards trial. So, yeah, I hear you when you say hopefully that this will disrupt things, but you also don't want to infuriate the judge by pretty much ignoring his court orders. You know, the two of them together went and said, Judge Hitler, in January, we need additional time. These in limine motions, Audrey, this is it. The case, I believe, could be won and lost based on these rulings right here. No, they are so important to both sides, to Mr. Koberger and to the state. And so why would you risk having your main expert witness thrown out because you're not following the trial order and the pretrial order and the January 31st order after you've lost motion after all of the DP motions, all of the suppression motions? I don't know.
What do you think, Eddie? What do you think going forward?
As far as the alibi goes, there has been, just a whole lot of back and forth with that. It seems, at one point, I think Anne even proposed an ex parte hearing, and there was no documentation of that ever happening, and the judge never ruled on it. It seems like the state wants to see the cards of the defense, but the right way, this is the state's case. The defense needs the discovery of the state, and the state is trying to, I think, do it in an underhanded way, so that they want to know what the defense's argument or defense is going to be with the alibi before, in order to be able to manipulate evidence. I don't know how else to say it. To do something in a sneaky, underhanded way, and the defense knows that. So I don't know. It's been just a long history of, like, with this alibi, like a game of cat and mouse, so to speak.
That's interesting. What do you think about that, Kathy?
No, I love what he's saying. But the issue is, can you imagine? Okay, I think of all of these motions in limine right now, the most important was the alibi defense. Most important. Because if they could somehow prove that he was elsewhere, then nothing else matters, right? Right? So why would you not file an affidavit in support of the alibi defense? Because right now, what the state's saying is Koberger is going to have to take the stand. If you don't have a witness who can support where he was, Mr. Koberger is going to have to take the stand. So why did they blow that? Why didn't they submit something from Cy-Ray? If that's what they've been saying all along.
Okay. I think that, go ahead, Eddie, go ahead.
Yeah, it seems like that would be reasonable, like if the defense has a way to prove it, but this is the state's burden to prove it. And we're learning that Cy-Ray is saying in this affidavit that the state does have the exculpatory information about Brian Koberger's true whereabouts, and they're hiding it. They knew about it all along, and they've never turned it over. So yeah, I see your point, Kathy, about, if the defense could prove it, but that is not how it should go. They probably do have the ability to prove it, I have no doubt. But the point is the state could have proven it way back, even when the investigation first began. They were able to prove it, but they've hid it, and they've chose to hide it. And why? And that is the point.
Well, Mr. Ray has not yet been subject to cross-examination. Okay, we've only heard, remember at the hearing when he was on the stand, it was just him and Ms. Who was it, Taylor, who direct examined. So he's not been subject to cross-examination as of yet. So we have to bear that in mind. And I agree with you, Eddie, no one ever is required to put up a defense. He could sit there like he's done. He stood silent, not say a word. He's done everything right, just in keeping his mouth shut, because things can be used against you. There is no doubt about that. But he willingly raised the alibi defense. And when you raise an alibi defense, you have the burden of proof initially that you were somewhere else. And then there's that shifting burden. Then the state has to prove that you were not. So why this 2-year battle of Cy is going to be able to, and you're not going to, at least as defense counsel with this man's life on the line, submit some type of an affidavit from him? This reminds me of what they did during the suppression hearings. Was Hitler was saying, you need to argue standing. You have to argue standing. And she just kept arguing policies and procedures, which was an appropriate argument maybe for another day, but not on a Fourth Amendment issue, because that means you have to say that this search or seizure was illegal under the Fourth Amendment, but you have to have standing to raise that. So this is what it's reminding me about. I'm very disappointed that if they were going to raise, and they did, if they raised that alibi defense, that they didn't follow through. They said that they were bringing Cy Ray in this case for the alibi defense. That was his main purpose. And then it got expanded to other things that were related as well. And for them not to, I'm like, well, are you doing this just to bill? To bill for hours? Because attorneys will do that. And then all of a sudden this is going to get dropped by the wayside. The most important issue right now
What do you
on
both think
these in
about
limine motions.
what do you both think about that the alibi and this document were strategic? And I mean that in the sense of the defense, they pretty much know the things that will go their way and what won't. So what if they had some idea that all of those things that they didn't win, we're just going to go like that? Because that's, I think, typically how things go. That they knew that dropping this at the right time would be very impactful and disrupt the flow of things. What do you both think?
Yeah, I think if I understand your question, I think that if we had the ability to know when disclosure was actually being received or turned over, rather, from the state to the defense, because like, what are we in, about like the 7th or so motion to compel? So the timing of how this has come about is key too, because the state has all along been dragging its feet on turning over discovery and making the defense appear late in these motions, and all the blame is shifted towards the defense being disorganized and whatever else. So did I am I understanding your question, Audrey, on that?
Yeah, thank you. Well, Kathy, do you think that the defense knew that some of these things wouldn't go their way?
No, I think that for Ann Taylor to sign her name and her bar license to a filing, she's got an ethical obligation to raise a legitimate issue. And just because there, and I just want to kind of go back, just because there's 7 motions to compel, and an attorney can always file a motion to compel based on a good faith basis. But the only ones they've won so far was partially on the 3rd and 4th motion to compel. That was back in Latah County when Becca Barlow got up on the stand and very convincingly persuaded Judge John Judge that the state needed to turn over the IGG evidence. And so we saw that very long order on October 25th, 2023, granting in part, but 1st, 2nd, 3rd, 5th, 6th, 7th, nothing's been granted as of yet. So I think, Audrey, I'm curious to see how they will perform at this hearing next week. These hearings are so crucial, and I hope that egos will be left at the door and the right people will get up and try and persuade, give their best argument that they can give to Hitler, because this is it. You know, this is it. These hearings are going to win or lose this case. The state's obligation is to prove guilt beyond a reasonable doubt. And what that means is of the evidence that's allowed to be let in the case. If the state's successful on these motions to compel and the defense is unsuccessful, that's not going to be good for him going forward. That's going to mean that the evidence that is presented to this future jury, who will be the trier of fact, regarding is that suspect vehicle 1 and does that belong to Mr. Koberger or not? Are the roommates believable or not? Was this purchase of this Amazon sheath and unaliving and the sharpener possibly, was that Mr. Koberger's or was it not? Did it go to his house and did his sister order it? That's the trier of facts role, not Hitler, not the state, not the defense. That's this jury. So these rulings are so crucial. And, if they have good faith reasons to keep out this evidence and it gets in, then that's just poor lawyering. And, his life's on the line here. But as I said, from what I'm seeing, I see a lot, juries have convicted on a lot less evidence. Unfortunately, we can, agree to disagree, and we can sit here and have all of these conversations, but that's the bottom line. Circumstantial evidence, a lot of times, gets convictions. And then okay, he can appeal. It's very hard to get a jury verdict set aside. And in the meantime, if he's innocent of these crimes, he's sitting in prison, as a target, because you know how other prisoners don't like people that get a lot of publicity. So, this is the time now to try to win and to get a ruling in their favor. And, I go back to the alibi defense. He raised it willingly 2 years ago. And now where's the affidavit from Cy Ray? Not been produced because they want to focus on other
I'm
things right now.
curious. I'm sorry.
No, that's it.
I'm
I'll shut up.
curious. Oh, you finished your thought.
No, I'm just saying, Audrey, this is the time to win or lose, on these in limine motions, and there's, as I said, I think that they lost a suppression motion that they could have possibly won. And I'm not sure why they even raised this alibi defense if they weren't going to submit a declaration or an affidavit from Cy Ray. I just don't, other than to bill on the file.
I think the only thing I would
Well,
see
I'm
to
curious.
all that, and who would disagree with what you just said, Kathy? However, if you look at the judge's order on the defendant's motion for Frank's hearing, he denied it. Same with the order on the defendant's motion to suppress the arrest warrants. He denied all of that. Does that mean that the defense lost that argument? Or could it mean something else, more sinister? I know in traditional cases, you don't have to think outside the box and wonder if there's corruption and if the judge is compromised. Now, in these upcoming hearings, it is true, this case will likely be won or lost on the rulings of the outcome of what these arguments are going to be in the courtroom. If the judge rules for the state, does that mean that Ann lost the argument? And I'm saying no. It doesn't. That's not the conclusion you draw from the judge ruling that way. Not in this case. Now, if that is me being a conspiracy theorist, then I guess I accept that. But that is the way, because we have seen now enough after these 2.5 years of what has been going on. And that is the discussion that people need to be having now, finally.
You
We
know,
know that the PCA is a compromised document, and the PCA is founded on fallacy and lies. And who can disagree with that at this point? So the state has been all along misleading, lying, in effect. We see in Cyray's document here, he says, in my nearly 30 years of working with and for prosecutors all over the United States, I have never witnessed such a deliberate attempt by prosecutors to mislead the court on evidence in such plain sight. We've all read the document. I won't continue, but what is happening here is unusual, and it suggests that they're all on board with this corruption. What are your thoughts?
well, thank you very much for your thought. A lot of my followers feel right now I'm 50-50. 50% of my followers are ready to send him to the chamber tomorrow. 50% feel that he's a scapegoat. And then we have, everything, I guess it's less than 50% or whatever. But if anything, this case stands for the proposition that we cannot, as a society, tolerate having so much information under seal. This case, since the beginning, every single supplemental request for discovery and every single supplemental response to discovery was filed under seal. And it's not because the defense wanted it that way. It's not because the state wanted it that way. It's because they both together wanted it that way. Ann Taylor drafted the first non-dissemination proposed order. She went to Thompson. Thompson agreed. They went to Megan E. Marshall, and that set the standard for the rest of the case. It was executed, I think it was January 5th, Audrey, if I'm not mistaken, 2023. And we saw the media coalition trying to get things opened up. They failed. We saw the Gonzalez family trying to get things opened up. They failed. It's only been now in January of 2025 that we start seeing information. We can't tolerate this. The First Amendment has always taken a back seat to this secret case, and I don't understand it. I still don't understand why it took until January of 2025 to get some information released to the public. And I hope that if anything is learned from this case, that this is not tolerated again, because anyone should be able to walk into any courtroom in the United States and watch proceedings and ask to see court files. This has not happened here. It took the media coalition, I believe, coming back a second time when he closed that IGG hearing on the 23rd and threatened to possibly go to the Idaho Supreme Court again. It was only thereafter that he then ordered that things needed to be more in the public. So that's one thing. A lot of people are saying, this also stands for the proposition of if you give your DNA, can the feds use it and everything. My main concern is the First Amendment and the beating that it took in this case. And
You
I'm
bring up a
seeing right
really
now,
great point,
I
Jeff.
believe Voir dire is going to be closed. I'm predicting it right now because of 2 or 3 things that I've seen. And if it is, I think that will be a travesty because voir dire should be open to the public. That's directly from the Supreme Court.
Now, I'm wondering if the First Amendment was so censored because the prosecution is aware of these timing advance reports, and to keep a cap on that, they needed to keep a cap on all of the information that was released. And I know that Ann Taylor first drafted the non-dissemination order, but that sentiment, I think, has morphed and changed as the court has gone on, and the more information that was exposed or even discovered to the defense. And then at some point, I think the prosecution did use it to their benefit to help protect whatever it is that they're protecting by keeping back these advanced timing reports. So yeah, I think you're right, Kathy, and I think that this is related to that. Very good thought. What do you think, Eddie?
Oh, that was a lot at once. Could you ask again could you summarize and ask again?
Oh, Kathy made a great point about how this case has been very centered. The First Amendment has been, violated. And I'm wondering if it's because of these advanced timing reports. And so the state had to keep a lid on the information that they released, because the more information they released, they risked getting discovered that they actually do have this, and they were withholding it from the defense.
Yeah, I guess I would have to mull that over for a while in order to, give a meaningful, thoughtful reaction to that. I'm not sure what to make of it sitting here in the moment.
Okay.
My argument is we as a society cannot tolerate secret criminal cases. Again, it was both of them that went to Judge Marshall and demanded a non-dissemination order. It was both of them that filed discovery and responses under seal. It was the defense that wanted all cameras out of the courtroom. And if Judge did not say, okay, we'll at least have the county having, the official live stream, we would not be watching. It would be like Delphi. We would not have privy to anything happening in the courtroom. But still, there have been so many secret hearings that have been held that the public did not find out about this until you look at the case summary page. And so I really hope that when people look at this case in the years to come, and I'm sure it's going to be studied in law school and it will be cited by other, that if anything comes out of it, that we cannot tolerate secret cases, that this is what makes us different constitutionally from places like Iran and Iraq and Cuba, where they have secret hearings, and secret trials. And we cannot tolerate this any further.
If I recall, the way that all came about when the defense was bringing up the issue about cameras in the courtroom, that was because instead of focusing on the proceeding, the camera angle would focus on everything Brian Koberger, and then in the mainstream media following that hearing, they would mischaracterize and misportray and have very manipulative way of showing, insinuating Brian Koberger's guilt and his mannerism and everything that tried to distract and cause people's opinions of him just because of his looks. And the resolution of that could have been, the cameras are allowed in the courtroom, but just not allowed to focus. But instead, the ruling was that the court would live stream its own court hearings. But then we've noticed that because mainstream media is no longer allowed in the court hearings, that now the court live stream is censoring itself. There's times when the live stream is shut off in closed hearing. So I don't know if I agree totally with everything you just said, because it wasn't because of the defense suggested that the cameras from mainstream media be entirely removed. It's just they didn't want the focus to be on Brian Koberger, their client.
Right, and this is the person who also authored the first non-dissemination order. We got to keep that in mind as well. It was Ann Taylor who authored that, and that's why we have not seen interviews. That's why we have never seen defense counsel give a press conference, as you do in other large cases like this. That's why you can't have an interview with the police. So now her thought was, and you're right, they violated Judge Judge's order to not focus on Mr. Koberger, but the theory, the resolution was not to remove cameras after you were successful in getting a gag order implemented in this case, and then they decide to try to set aside the gag order as to the IGG. Well, what about the rest of the filings? Why didn't you seek to lift the gag order altogether? Why is it just then you want it removed as it related to IGG? That to me says the people are looking to make a name in this case, and perhaps are not looking at what is in the best interest of their clients. That's just my opinion, because it's got to be one way or the other. Either you want it to be open for everything, or you don't want it to be open for everything. You can't pick and choose what it is that you want things to be open for. And let's hope that these hearings on the 9th are open to the public. It looks like they should be, because most of the in limine hearings are publicly, they're public documents. But there are a few that relate to the grand jury where we may see them go into closed session. But for me, I'm 100% First Amendment. I think everything should be open to the public. Stop with this hiding things. Both sides, defense too, and prosecution. Stop it.
Yeah, it makes sense. I agree with that.
Eddie,
Yeah,
are you going to be
so-
around on the 9th?
Eddie?
Is Eddie there?
Yeah, I'm here. What was the question?
Yeah, we're going to be live streaming on the 9th, just kind of providing commentary. More than welcome to have you come and join us. We're going to be, I'm doing a live stream on the 9th to do gavel to gavel coverage. Audrey, you are as well, right?
Yes.
Good, because the more I think that, whatever side of the aisle people are on, I think it's important for people to show interest in this case. So this doesn't happen again, where we have these cases argued up until 2 years later under seal.
I am so concerned that it sounds like it's standard practice, regular protocol that happens all the time in investigations, that these timely advance reports are discoverable and they are released, and that it's taken this long to provide those. And not only did they not provide them, Cyray was able to determine that they do exist and they were used. I don't know how we prevent that from happening too. And I guess the first step is, stop sealing everything so we can see what happened. And so now we're starting to see what happened here. And this is just, that's this a violation of so many things, I think, not only like policy and regular investigations, but could this be another Brady Giglio that they withheld this foundational piece of evidence? What do you think, Eddie?
It sure feels like it, yes, in my opinion.
How about you, Kathy?
Well, remember, Cy has not been subject to cross-examination yet. For whatever reason, Thompson decided not to cross-examine him in Latah County, and I thought that that was a big mistake. But based on this, first off, will he be admitted as an expert? That's number one. Hippler has to recognize him as an expert. And he was prevented from testifying in a case in Colorado. The court did not find him to be credible. All right, so we've got to keep that in the back. It's not a given he's going to be able to testify. Number two, how will he hold up under cross-examination from a David Nye? Keep that thought open. This is the beauty of our legal process. Both sides, you make a statement, great. Now you're subject to cross-examination. Same with the two roommates. Not Mr. Koberger because he's not required to take the stand, but everybody else in the case subject to cross-examination.
Yeah, I think that's going to be difficult for Jeff Nye, because, Cy Ray is the one who created this field, and he's the one who trained thousands of officers and agencies, including DEA and the Department of Homeland Security. So even if Nye is a pretty clever prosecutor, I think it's going to be very difficult. But it just, I guess it depends on Nye or whoever is going to cross-examine him. Oh, great question I have. Let me know, Eddie and Kathy. Oh gosh, Kathy, you bring up great stuff. Is it going to be appropriate for Ashley Jennings to cross-examine him on these accusations, or would it have to be another prosecutor?
That's a good point. No, I see. I will, if I were a betting person, Audrey, and you have known me long enough to know I'm not, right? Eddie, Audrey and I go back a very, very, very long while, but I don't see Ashley Jennings cross-examining Mr. Ray. I think it's going to be Jeff Nye. And remember, everything that's said here has not been subject to cross-examination. This is just Cy Ray talking about his credentials. This is the beauty of our legal process, is the process of, this is exactly what the defense is arguing about, the 911 call and the text. You can't sit there and cross-examine a text or a 911 call. You need people in the courtroom, because hearsay, although the state has raised, I think, pretty decent objections to why the 911 call and the text should come in, you can't cross-examine, a piece of paper. You need people in the courtroom. And that's when the truth usually comes out in terms of don't take this the wrong way, but sometimes experts, overly boast about what their credentials are. And Cy Ray's not saying here that he was not admitted in Colorado because the judge there found him to be untrue, not, what did he say? His technology was junk science and he was not credible. That's not, you better believe that's going to be question probably number 4 from Nye when he gets them on the stand. So we have to wait until every witness is subject to cross-examination regarding whether or not what they're saying is truthful or not. And hopefully that will be, in the public arena. If these hearings right here, right now, are not public, that's going to be very sus.
Yeah, as far as what happened in Colorado, I've got no background on that. I'm not sure what you're referring to, or if any of that, what, like read Twizzlestick's comment about that. He seems to understand more about it than I do. There seems to be more to the story. But as far as Cyril goes, he seems to be the authority in this. So if Judge Hippler were to deem him to not be a credible witness or someone who could be viewed as a witness in this case, that to me would feel suspicious. There'd be something off about that.
Well, let's reserve ruling until after we see him, sustained after, because right now all we've heard is from him. His affidavits, his getting up on the stand with Ann Taylor. He has not been subject to cross, and that's a lot of times. You'll recall, I think Yoli had said that's where the truth comes out, Audrey, right? During cross-examination. That's where the truth comes out. And I'm going to tell you right now, what I don't like that he said is he said that his opinion is not subject to a dispute by the experts. That's not for him to say. It's like, well, his opinion is so airtight that it's irrefutable. That's up battle of the experts. That's what it was. That's not for him to say. That's for the judge to determine if another expert could overcome what he's saying there. So I thought that showed a little bit of arrogance on his part. Nobody's opinion is 100 airtight, and there are other people, other experts that could challenge anyone's opinion. So as I say, let's reserve ruling on all of these experts until after we see them on the stand during cross-examination. Hopefully it'll be public.
So, Kathy, I agree with you. It shows arrogance there that he said, this is not a battle of experts. But I do think he wrote the policy, he wrote the training and what they have to go through, and he knows the legal process. He says that the legal process was not followed by the state. So if he's the one, I keep thinking about it from a systems point of view of policies and procedures. So within investigations, law enforcement also follows some procedures and investigation. I think there's some checks along the way. And as Cy was saying, there are paper trails. And the paper trails that he has seen within the emails and with the other discovery is that those paper trails are there. However, they weren't disclosed, and he found that they were deliberately being hidden. So when he says a battle of the experts, I think he's right, because he's the one that basically wrote the policy on how law enforcement is supposed to go about that with the chain of custody.
Well, who has cross-examined that point? Or is this just him saying it on, people, I don't want to say, lie, but they boast on their resumes all the time. They over exaggerate what their background, what their skill is. This is just Cy Ray saying that he wrote the book or whatever regarding. We need to wait until after he is on the stand and see how he does after he's subject to cross-examination. Because as of right now, this is just one-ended. This is coming from him. This is coming from the defense. And that's the beauty of cross-examination. That's where, the rubber hits the road. When you're challenged on a point, people all the time overstate their skills, their knowledge, their experiences on just resumes for jobs. So, okay, this is what he's saying. I'm sure he's not, intentionally fabricating, but wait until he undergoes cross-examination by Jeff Nye, and we'll see what happens at the end. He may come out smelling like a rose 100%, but right now we only have this information from one side in a case that has been under seal for most of 2+ years.
I think this is a one exception to the rule. Because like Twiz says here that Cy wrote the software, he created the field for using this type of technology for investigations. That it's not a battle of the experts, for one, because Balance is not certified. He didn't take any of the courses that Cy wrote. And apparently you do need certification to be able to use this type of technology in an investigation. And so
Okay,
I 100%
what court has
agree
made,
with
as much
you.
as I love Twiz, I think Twiz is the cat's meow. Hi, Twiz. But what court has made that finding? What court has made the finding that Cyray has written the book on this matter? Nobody.
I don't know
You
if
know,
they
him
need
going
to.
on, Truth, Lana's, whatever show and speaking with her after he testified in the case about what his credentials are. That doesn't mean anything. It means in a court of law. What judge has made these declarations about him?
Yeah, I don't know if the court needs to, especially with that this is the expert in the field. He's taught all the other experts. And so he's basically informing the court this is how it goes. And I think this is an exception to that.
I think I have a pretty good ability to determine whether people are fluffing, are acting flamboyant, throwing up their feathers like a peacock and over exaggerating their self or their ability or boasting. And I think most people have the ability to understand if this is a case of Cyray misportraying or overstating his qualifications. And I'm just not getting that feeling here. That's not my take or opinion when I read these documents. The truth doesn't need to raise its voice. And when you see the litigators in the courtroom during these hearings, we all witness Ashley Jennings struggling, to say the least, when she was making her closing argument. And I'm sure that's not a result of her being a poor litigator or unable to understand how to do her job or being inexperienced or bad at what she does. But when you don't have the truth on your side, that is going to be the end result. So again, if a judge is going to deem Cyray to be not a qualified expert in this, that in itself is going to be alarming, and it's going to be a tell, and we'll know what to make of that. And I'll leave it at that. It's what is going on in this case is pretty simple to understand. We just need to use our reasoning skills, our deep thinking, and short of calling it a conspiracy by all, these rulings on these upcoming hearings is going to tell us, like you said, Kathy, it's going to tell us the way this thing is going to go moving forward. I agree.
These hearings are not to be missed. Anyone who is really interested, legitimately interested, you've got to watch them. Hopefully, we've gotten some information that most will be live streamed. Please, if you can, watch it live streamed when it's happening. If not, on repeat, we'll be live. Audrey will be live. I hope that you guys will also be live because at the very least, again, my main concern is just how long and how much it's a Mount Everest of information that's been under seal for too long in this case. We cannot tolerate this as a country. This is not Iraq, where you get to have the luxury of these pretrial hearings, on a DP case, 4 students unalived. And we still don't know what this case is about. We're getting information about it, but there's still too much that's been held under seal. And I say again, it's both sides who wanted it that way, not the state only, not the defense, both sides. The judges have permitted that. That's my main gripe about this case.
Yeah, it's a good grape to have. Yeah. I think this document is historic. I mean, it's not every day that somebody writes with this much language, and strong language and to the point. It's really piercing. I am like you, Kathy. I'm very interested to see what kind of response. I mean, like what can actually happen here. Um, I guess all they could say is no, we never had it. But then, how do they address these claims that are apparently in the emails that Cyree has read and has seen the paper trails for? How do you think they could respond, Eddie? Oh, is my mic not on?
It sounded like it cut out.
Ah. If you can hear me now, how do you think they could respond to this, knowing that there's a paper trail showing that they did do this?
We're hearing just from one side right now. This is Cyree's interpretation of what these emails say. You're right. We need to hear the state's response to the same. And with respect to Ashley Jennings, she does seem, a little less confident when but bottom line, she's won every hearing, every motion. Ann Taylor has lost every motion.
Mm.
That's the bottom line. Ann Taylor has lost all of those suppression motions. And there was at least one that I think was really winnable if she would have gotten off her high horse and stopped arguing policies and procedures and arguing standing. Imagine if the motion to suppress would have been granted. That meant that everything was fruit of the poisonous tree. And Hitler said to her, but you're not arguing standing. And she went back to policies and procedures again. Like it or not, he's the judge. He's the judge in this case. You need to persuade him. And he has said already, he's not going against precedent. He is not going to go against precedent. He said that during the DP motions. You've got to argue precedent. The people who are going to win at these hearings are the ones who most successfully argue precedent. Hitler gives Easter eggs away. You can look at his face and his body language and know where he's leaning, plus the questions that he asks. And also, precedent is very, very big with him. So we're going to see, this is next Thursday and Friday, 2 days that could really change the course and scope of the rest of this case, no doubt.
Well, you covered a lot of ground with that answer. But I think we started out with the response to Cyree. We haven't heard that. But the point of the question was more about Audrey asks, he's got this paperwork trail. And let's just go, for the sake of trying to get that question answered, let's just go with our assuming that that is the case. It is a truth that he has this paperwork trail showing. That is of significance to talk about, in my opinion.
Where's the paperwork? We have his interpretation. Where are the emails? Why didn't the defense publish those emails? Then we could look at them and we could say, you know what? Right. Okay. Yeah, I get this. I see where he's coming from. What we have is his interpretation of what those emails say, not the emails themselves. And this is that's a pretty big allegation to make, that she intentionally engaged in misconduct. Why aren't you publishing the emails themselves?
And again, like I was trying to express earlier, who knows about, we're discussing this with the advantage of knowing the full history of it now, but in that real time when the discovery actually came into the possession of the defense is, to me, that would need to be more understood as to why it's just coming out now. Hopefully that makes sense. My trying to describe my thoughts there, but
Oh,
the other thing,
100%. 100%. But why are we having to take what a third party is describing what these emails say? Why not just publish them? They published photos of suspect vehicle 1 at the corner of Queen and King. They published the text messages, 911 call. Why are you hiding with these emails? Say, give the public the opportunity to read them, and we can make out. We don't need Cyray to interpret what they say for us. I think we're intelligent enough to do that for ourselves.
Good point, Kathy. I think they should release those. What do you think, Eddie? Should they release them?
well, maybe we'll learn more about them during the hearing, certainly.
Yeah.
I don't know the reasoning why they didn't. You mean like in the document itself? Is that kind of what you're
Yeah,
saying?
I'm of age. I don't need Cyray to tell me what it says. Why don't you publish and say attached here to is Exhibit A is the email from who was it, Mallory to Ashley Jennings, and that publish it. I don't need Cyray to tell me what they say. I would like to see the actual emails myself. That's just me.
Yeah, well, maybe they have a reason. Who knows what it could be? Maybe it feels like the defense might know something that the state doesn't want getting out there. So maybe they're leaving, maybe they're being gracious and giving the state some play and some wiggle room to be able to figure themselves out.
Well, if
before.
that's the case, then redact it. Point to exactly where you're showing me that this woman should be in jail, because that's basically what this is saying here. Show me where she intentionally engaged in misconduct, and you can redact the rest if there's some reason why. Right there, I find that sus. I don't need Cyray to tell me what emails say and don't say. I would like to make that, and I think my followers would like to make that conclusion for themselves.
Intriguing.
That's true. And this.
Yeah,
Go ahead, Eddie.
interesting to see. Yeah, it's intriguing. That's for sure. I'm sure there's a reason for it. I can't foretell what that could be at this point, but it's very calculated. Whatever steps one side or the other takes is very cautious and purposeful and calculated. There's no doubt.
And that suggests that we, the public, are being manipulated here by both sides. And I think that there's too much on the line. You have four young students whose lives were taken in the most atrocious manner possible. You've got a man whose life is on the line here. And you're going to play games back and forth you're going to make these types of accusations against a woman without providing what you mean. I think that it was incumbent upon them to produce those emails. And if there was any reason in the world for them not to, they could have redacted it, right? But, women have been attacked a lot in the workplace. Law is not a place where women have typically engaged in the practice. It's been dominated by men. So that's part of what I am bringing forward here as well. That Cyray is attacking a woman who's a minority in a field that is dominated by men, and we're supposed to just, oh, okay, yeah, you're right. I want to see the emails, show me the money, like, what's his face? Cruz once said.
You think he's playing the woman card? He's attacking a woman?
I don't know. Why is he hiding it? Why is he hiding it? She is a minority in a field that is dominated by men. I will tell you that for a fact right now. The legal profession is 74%, I think, male dominated. So here we have another man who's going to come in and attack a woman, say that she basically needs to be in jail because she engaged in misconduct, but we're supposed to believe him. You know, we're supposed to 100% believe him without showing us the money. I want to see the money. I want to see the emails, not what Cy Ray has to say. I want to see the emails. He has made some serious allegations against her. I want to see the emails, not his interpretation of what the emails say.
Well, I'm
So
sure
what
he
if
comes
he's like, because
prepared.
I know he mentioned in there that he was like, there is a bigger issue here. That the reason why that they didn't hand over these time in advance records is because there's a bigger issue here. So maybe he is planning to do that, but he was just like, look, I'm going to lay this out here right now, your move, but I still have that going on. And also, in a way, I don't know if that would have been the appropriate move to lay all this out and then lay all of the emails out in perspective of, being a woman in a workplace, that he would just full on attack her and then release all of these emails. So I don't know if that would have been
I'm just
right. I think
saying,
this way, look.
I'm just saying, you just basically talked about two specific emails from Mallory to Jennings and Jennings back to Mallory. Those are the ones I would like to see. I don't want to have Cy Ray tell me what they say. I want to see them because he has made some serious allegations against her.
Well, I'm sure he comes prepared to back it up. I'm sure they're not empty, accusations.
I don't know. I'm not going to take his word for it. I want to see. He has made some accusations against a woman who is working in a field dominated by men. So I would like to see.
Does that have to be mentioned like that?
Yeah, no, it does. It does, because Cy Ray is not married to an attorney. Cy Ray is married to a woman who supports him. Okay? So I want to see, as a woman who has experienced this type of bias, I'd like to see what he has against this woman to make him attack her and basically say she needs to be in jail. I don't want to hear it from him, supported by his wife who supports him, who's not his equal, but supports him in his role. And he's attacking Ashley Jennings. Now, we can sit here all day and night and attack Ashley Jennings, but she won quite a few motions in this case. So why is he attacking her? Is he trying to keep her down? I understand he's also
I think
attacking
he has
Mallory,
evidence.
but the great attack is against
I don't
her.
know if this is attacking when he has evidence, and I think he's being respectful, where he's like, look, Judge, here is everything that I know. I have everything. I'm going to bring it with me, and I will show you then. So he wants to directly show the judge,
I think that he should have attacked, making these types of assertions against her. He should have attached those emails, not given us. We don't need to be spoon-fed by Cy Ray or anyone else. I would like to see those emails. You're gonna sit here and describe them to me?
I think this is as professional as he could have done it.
No, I disagree with you. I think he could have attached those two emails. And he didn't. So we're supposed to sit here and say, because we're so infatuated with Cy Ray, that we have to sit here and believe what he's articulating here. No, I want to see the evidence. If you're going to open up that door, prove it. Don't hide it. Prove it. Attach the emails that shows us that this woman belongs in jail.
I think he will, but I think that would have been attacking her if he would have attached the emails with this. That would definitely be a full-on attack. I think he is trying to be respectful because of the gravity of the situation. I mean, the appropriate thing to do is say, Judge, look, this is everything I have, and I will give you more information. I think he was basically saying, this is a tough situation for him to be in, having this paper trail of these things that she's done.
I guess I'm a little unable to negotiate this. I mean, the fact that you're bringing her gender into it and acting like she was attacked, that's got me at a loss for the moment. I don't
she
know.
was attacked. She was. He told her. He
But if
told the
she was,
world that
if
this
she had been
woman
a
belongs
man,
behind bars. I want to see the evidence. I'm not going to take it by a guy who's supported by a wife who does not work in as an attorney, who supports him in his role. I want to see the evidence of what he has against a woman who's his equal, that she belongs behind bars. Why is he hiding that from us?
if it had not been Ashley
I don't
Jennings, but
think
it
he's
had been a
saying it.
male that had done that, right? Then what would be the argument? Would it be the same argument that the
I
male is
said I
getting
want to see
attacked?
I want to see the emails themselves. I don't want to hear it from
Well, I get
Cyrate.
that. We all do.
I want to see the emails. I want to make my own decision. I'm perfectly capable of making my own decision. I don't need Cyrate to tell me what those
Right,
emails
but you've
say.
already said that. We get that. But
Okay, well, so you're going to believe Cyrate. I understand that. And that's your prerogative. I want to see the emails. He has attacked
it
this
has
woman.
not
She belongs in jail, according to him. Where are the emails?
nothing to do with I'm gonna side with Cyrate. That's not what this discussion has turned into. It is that she's a female and being attacked. Would it be
Well, what
that
is
the
she?
male, if it was a male that did it rather than Ashley Jennings, then would the male be attacked by
I'm
Cyrate too?
saying I have seen this before in the workplace where a male sees a woman as a threat. So he decides to go after her.
But that's
I
not
want
what's
to see the
happening.
evidence.
That's what's happening here? Is that what you're saying?
I'm going to say this one final time, okay, because I'm obviously not being heard. I don't need Cyrate to tell me what 2 emails say. I want to make that decision for myself. End of discussion.
Okay. Well, let me ask you both a question. What was it that was the first thing that made you go, I want to know a little bit more about this case, or that doesn't sound right, or what was it that drew you in? What about you, Kathy? What drew you in?
I think the tragedy of this case, that it was 4 young people that were unalived in their home, that's what drew me in.
All right. How about you, Eddie?
To me, as soon as I saw the first press conference, I knew right then and there that something was off. Notice during the first press conference that the narrative was a lone suspect, singular. And now we're learning, what's it been, over 2 years since, that narrative of a lone person was interjected, planted, and put into the narrative much before that first press conference. It was in the moments after the crime happened. This thing was on from the first moments. Who knows if it was on even before the crime happened? I don't know. But the state is aware that Brian Kohlberger is innocent, and the judge knows it too. And we have all looked at this PCA as soon as it came out And we gave it its due diligence, and we tried to look at it as though it was our source for facts. And we all dove into it and dissected it and debated over it and determined that even back then, probably about 2 years ago, when we were talking about it, we all, when I say all, I mean some, agreed that it is useful as toilet paper. And as it turns out, we were right. Our intuition served us well back then. It is full of lies and it cannot be trusted. And the author of those lies is continuing to push this narrative and all these lies upon us. Now, if I lied to you 9 times, the 10th time I told you something, would you be inclined to believe me? I say you'd be a fool if you did. So anything that comes out in these documents that is from the state, it is not trustworthy. They have shown us that they cannot be trusted. I do trust the defense. That is our source for facts in this case. And that's, I guess, as good as I can explain about what I think about this case.
All right. Well, for me, as Kathy knows, Kathy and I, we read through that PCA front and back. We can almost recite it. You know, this is how Kathy and I met. We would just go back and forth and just talk about how could this happen? How could that happen? What does it mean when it says this? And I think I knew very early on from reading that, that when they said they found DNA and they weren't telling what type it was, that indicated to me right away that it was transfer. And then I noticed as time goes on, if you notice, the state had never said what type of DNA it was. I think it first came out, was it Ann Taylor who called it touch? And I don't know if it was her declaration or if it was the response or the objection to the protective order. But that was the first time we ever heard what type of DNA it was. And I just kind of glued onto this case, the whole DNA aspect of it. And as you know, Kathy, I started to post DNA articles on Twitter just to kind of get people used to, well, what kind of DNA is it? How does this work? And I wanted to make sure that I gave them all the links. So I'm like, if you want to see what I'm reading, here it is. Like, and this is how it goes. And I was hoping that I could break down these scholarly journals and kind of put it in a way where it could be packaged from like, because, you know, I'm just a regular person. And hopefully the regular person can, you know, make it kind of easier to understand that these things. And I know the whole community as a whole, they've absorbed all of this DNA information, which I think is absolutely amazing, because I think we should start getting away from DNA as this gold standard. Even blood, sweat, semen, saliva, even those are not quite the gold standard, and they were never supposed to be. DNA was supposed to be just, you know, supporting evidence, and all the other evidence that we traditionally had, they were supposed to be uplifted by this. But I'm not sure if it was TV that glamorized this DNA, and you know, I'm also fascinated by it because of it walks that gray line of, is it health information? Should it be used as a law enforcement tool? And then in the time that I've been here, I've been able to share like everything I know about DNA and like how it does respond to like different frequencies and like how that changes our moods, and you know, just how beautiful DNA actually is, or how information is coded in it. And I do think that like science and, we all have seen those boring pictures in our science books that make chromosomes and DNA look so boring. So I really like how I can make them look crystal or DNA, because I do think there's something more to it. I do think they're like made from the stars or the cosmos. Isn't that true that we're just like stardust? Isn't that? I think I've heard that somewhere. I don't know. I can't remember. But I think it's so incredible that this community has come such a long way in learning what transfer is. And now we're all learning along Bika Barlow, and the how and the when is so important. Was it direct? Did someone else transfer your DNA? Did you sneeze on someone? Was it secondary, tertiary? And how do we know what time? That's so fascinating to me. It's like, what time did this happen? It's like the only way you would ever know what time is if you were actually present at the time it happened. And to me, there's so many questions, and I know like all of us here, we all like to question things. And I think that's one of the things that we all have in common. And there's so many questions about this transfer DNA that, it's just all these questions. And I just wanted to say, I am so honored that both of you came up on the panel. I would like to schedule another time for you and I, Kathy, to have you as special guest. And Eddie, I would like to invite you again so that we could showcase you as a special guest. So we have our own shows. And then maybe in another time we can do this panel again. This was so much fun, even though it was like impromptu, there wasn't really any planning. I just thought, well, we were having such a great conversation earlier today that I wanted to carry it over. And it is so amazing to talk to people that have all of this information, all of their different backgrounds, because we all bring something so unique. And I've learned from every one of you. So thank you both for coming on.
And thank you, Audrey, for having us.
Well, I don't know if you email Eddie, but my email's in the description. I would like to schedule something with you. And then Kathy, we talk how we talk, and I look forward to the next time that you and I can get down to the, what's going on. Like, what would happen? What did you think about Hitler? What did you see? Kathy, I think that's so exciting that you can do that. Anyway,
listen, Audrey, you are a great host. Eddie, I really enjoyed our conversation today. I want to thank everyone in the audience. April 9th and 10th. That's when the rubber is going to hit the road in this case, people. Please watch the hearings. And Audrey, Eddie, thank you. Thank you so much for your time today. I really appreciate you both.
Thank you, Kathy. It's always a pleasure.
Bye. Bye, everybody.
All right. Bye. Bye, everybody.